Okay, I think we got everybody in. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I work as the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in our A Month of Service collaboration. Also included, on behalf of our presenting partner, we have Lone Star Legal Aid, and Mr. Benjamin Daly is going to be providing the information for you today on today's topic. But also included in our partnership, we have the Earl Carl Institute, Texas Legal Services Center, the Harris County Attorney's Office, Houston Volunteer Lawyers, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and the City of Houston's Department of Neighborhoods. And together we make up a month of service. And a month of service basically is a collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the communities that we all serve relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. And one of those presentations is, of course, evictions and knowing your rights. We know that there are a lot of individuals throughout the communities who don't know where to go for particular resources, services that are available, and just need information about any life issues that are happening, and how do they handle it, and what do they need to do in those particular kinds of situations. So we decided to collaborate several years ago in an effort to reach more people and to create a larger impact and pool a lot of our collaborations together. So we decided to provide you all with the information provided by Lone Star Legal Aid with about evictions and knowing your rights. The way things are going nowadays, it's a lot for a lot of people. The cost of housing is going up. The availability for affordable housing is getting, so smaller and smaller. And, a lot of people are still facing financial hardships and unfortunately facing evictions and don't know what that process actually is, or what eviction actually means, and what your rights are as a tenant. And so we're going to provide that information here for you today. On behalf of the collaboration, I want to thank you all for joining us this afternoon. And we hope that you get the information that it is that you intended to receive by joining us today. Do know that we are recording the session. We do also broadcast live on our social media platforms. So we do want you to be as interactive and as engaging and ask your questions. As you need to ask, we do ask that you try to keep your questions to be as general as you possibly can, because we don't want you to divulge any personal, specific, detailed information about your particular circumstances. So try to keep your questions to be as general as you can. We want to, again, protect your privacy as best as we can. So do know that the information that does get provided here today is for educational purposes, is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourself in need of any civil legal assistance. And Benjamin's going to go over a couple of other areas that Lone Star Legal Aid assists, not just in relation to eviction, but for the topic for today, we are here strictly to talk about eviction stuff. So with that being said, we're going to go ahead and get started, and we're going to have Mr. Benjamin Daly with Lone Star Legal Aid introduce himself, and you can go move right into your presentation.
Thank you. So my name is Benjamin Daly. I am a staff attorney with Lone Star Legal Aid's Eviction Right to Counsel Unit, and this is Evictions, Know Your New Rights. New rights obviously being because at the beginning of the year, the legislature passed some new laws regarding this process, and so some of what we've been practicing under the last few years has changed rather drastically in the last few months. Before we get into that, though, a bit about There we go. Before we get into that, a bit about our firm. Lone Star Legal Aid is a nonprofit law firm. We represent low-income individuals in a variety of civil legal matters. We have units that address both specific legal issues, for instance, evictions, but also units that can address a variety of populations and the concerns they have. So, for instance, we have a veterans unit that specializes in serving the veteran population and can do all sorts of things that we in evictions can't because of the narrow scope of our work. And we can also provide both advice if you're having legal issues, or in certain cases, we can take on full cases. You can apply at our website, lonestarlegal.org, or by calling our number, and I'll make sure that we come back to this slide at the end of the presentation. So the agenda for today, we're going to be talking about leases, about terminating the lease, about what an eviction looks like from the first notice to vacate to a final judgment. And then we'll be talking about some other issues that you might see if you're a tenant and dealing with a dispute with your landlord. All this is general information, but keep in mind that a lot of cases turn on specific facts. If you're facing eviction, it always makes sense to look for assistance, either with our firm or with another firm that does eviction defense work. And then, just as a general rule, we always recommend that before you file a lawsuit, you talk to a lawyer. So, in order to understand evictions, you first have to understand the relationship between the landlord and tenant, which is established by the lease. A lease is an agreement between a landlord and tenant. It's going to establish the rules regarding the use and occupancy of a dwelling. Note that a lease is a contract, legally speaking. In Texas, you can have either a verbal lease or a written lease. If you do have an oral lease, you want to take steps to document the terms. And you do want to note that if the lease is for longer than a year, the agreement must be in writing. You have a right to a copy of your lease within 3 days of it being signed by all parties. If you did not receive a copy of the lease, if it's written, ask for it and make sure that the request is in writing. Keep in mind that leases are going to control in most disputes, and that leases under Texas law can do a variety of things. They can even alter certain rules or waive certain rights. So you want to make sure that you're familiar with the terms. So what's actually contained in most written leases? So first, you're going to have the establishment of what rent is. So most rent is paid monthly. It should tell you what the amount is, when you need to pay the rent, where you need to pay the rent. It's going to establish what happens if you don't pay the rent, such as the imposition of late fees. And it may include language that states that the payments can be applied to rent or applied to other charges. So you want to pay attention to the section concerning the amount of rent and the amount of payments. It's going to establish an initial lease term. Most written leases last for a year in this context. Most written leases also include language which would renew a lease term month to month at the end of the written term. And you want to read to make sure that there are, whether or not there are additional fees or whether it's subject to a rent increase if you don't sign a new lease at that point in time. Lease will usually make reference to community rules and policies. These are the rules that the office may promulgate. Keep in mind that if the lease says that the rules and policies are incorporated into the lease, even though those rules are subject to change, they are part of the lease. And so violating those rules constitutes a violation of the lease. The lease may include signed addendums that can include things like concessions. If you're in public housing, it could include a HAP contract, which would change the terms of the lease. Parking addendums, basically anything outside the main lease that is referred or incorporated into the lease would be referred to as an addendum. The lease will usually define acts of default. That can include things like failure to pay rent. We call conduct-based breaches, so not following the apartment rules. It will also go over what might be required for early termination, or it may provide information on what happens if there's a holdover at the end of the lease term. The lease can provide timelines. As I've mentioned, a lease can actually alter the timeline provided by the statute. So, for instance, the statute requires a 3-day notice to vacate. when they're asking you to leave prior to filing an eviction, the parties can contract for a shorter or a longer period of time. So under a Texas Apartment Association lease, that can be as low as 1 day before you can file an eviction after giving a notice to vacate. So you want to pay close attention to the timelines. Finally, there may be a section authorizing the use of electronic communications to deliver notices. Prior to this year, notices to vacate could not be delivered electronically, even if no other notices could be delivered that way. That has since changed. So you want to pay attention to whether or not the lease authorizes the use of electronic communications for those notices. Um, Moving on from leases to the termination stage. After initial lease term, either party can terminate the lease by just providing proper notice. There's also early termination that could occur, and we'll get into that in the next few slides. Um, but refer to the lease and see what it says about terminating the lease. Oftentimes, these leases include language which requires advance notice, 30 days if you're a tenant, terminating the lease at the end of the lease term, or it may require the landlord provide a certain amount of time to terminate the lease. Keep in mind that terminating the lease actually does require written notice. You can't simply orderly tell your landlord, I'm leaving, and then have that be effective. You want to actually have something in writing, and vice versa. The landlord can't just tell you to get out. They actually have to provide the termination in writing. So early termination can kind of come in two forms. There's a tenant's right to terminate early, and then there's a landlord's right to terminate early. And we're going to start with the tenant's rights because there are a lot of sections of the code which do, in fact, provide a tenant the right to terminate the lease if certain things happen. Keep in mind that the statutes are going to control in those circumstances, but some of those rights can be waived. So you're going to want to, if you're thinking that you might want to terminate and fall under one of these sections, you want to refer back to the actual code before delivering the notice of termination. You do also want to review to see if your termination rights are violated. There may be a cause of action there. And obviously, if there is, you should speak to an attorney for taking steps to exercise your legal rights there. Some rights to early termination of a tenant in cases of family violence, in cases of either sex offenses or stalking. In the case of a tenant's death, termination can be used to avoid future liability, although past due obligations are still recoverable. And then there are certain rights to terminate if you're in the military and called to active duty. Additionally, casualty loss we need to spend a little bit more time on because we do live in Houston and we are unfortunately subject to extreme weather like hurricanes and flooding. A casualty loss, early termination, casualty loss refers to any time you have a loss that's incurred due to disaster. The statute provides the right for a tenant to terminate the lease if the property is damaged to the point where the premise is unsuitable for residential purposes and the loss is not the result of tenant's fault or negligence. That right to terminate goes both ways. So the landlord also has the right to terminate the lease once the property becomes totally unusable for residential purposes. If the premise is not made totally unusable, but only partially unusable, there actually is no right to terminate, although the tenant could ask for a reduction in rent if the landlord won't give it and won't make repairs. The landlord does not have a right to terminate because the premise is made only partially unusable and not fully unusable. The question of whether the premise is made unusable or to what degree it's made unusable, whether total or partial, that is a fact question. If you are in a situation where either you're looking to terminate due to casualty loss and the landlord won't let you out, or if the landlord's trying to terminate and your position is that you want to stay, you want to talk to an attorney for additional review of the facts. So now we sort of get to the beginning of why we're here today, which is what happens if a tenant is facing an eviction for breach of the lease. So as discussed, the lease is going to define what a breach of the lease is. It could be any violation of the lease terms, condition, rules, or other provisions. Some common defaults that we see: failure to pay rent, either in full or on time, a repeated violation of community policies, having unauthorized tenants, if that's prohibited by the lease, criminal activity by the tenant, occupants, or guests, or in certain cases, holding over does kind of fall into the same category. If a breach of the lease occurs, the landlord must provide proper notice before filing an eviction. So just because there's a breach doesn't mean that the landlord immediately gets to run to court. Keep in mind, and I'm going to probably sound like a broken record for a lot of this presentation today, the lease is going to control in terms of defining what constitutes a breach of the lease. When it comes to things like the community policies, oftentimes these policies are written in ways which gives the landlord rather broad discretion about what sorts of behaviors actually constitute a breach of the lease. So, for instance, we've seen people who the landlord seeks to evict because they were rude to a member of staff. So you want to be very, very familiar with the rules that you're renting under. Important to know in the context of lease termination, is sort of a special case of what happens if I'm on public housing. So public housing looks a little bit different from most evictions because whether it's Section 8 housing vouchers or project-based housing or long-term housing tax credit or any other programs, oftentimes there are special rules that regulate when and how a landlord can terminate the lease. So, for instance, all public housing is going to fall under something called the CARES Act, and we'll talk about that shortly. But in those cases, they can't simply give you a 3-day notice to vacate. They actually to give you a 30-day notice to vacate. In a lot of cases, they have to notify you if there are breaches of the lease and provide you an opportunity to talk with the management prior to filing an eviction. The regs give, I believe, 10 days, 10-day period to request an informal hearing. You should be aware that the public housing programs all have slightly different rules. And so if you are on public housing, you're going to want to be familiar with those rules and look at whatever the source of the rules actually is, whether that be the regulations or if you're on Section 8, the HAP contract that governs. And then obviously, if you are having issues while on public housing, you should apply for services, given that there are a lot of special rights. And this could be an area that's a little bit more difficult to navigate as a tenant, even if you do end up having more rights at the end of the day. Another sort of special case that we see often is, what happens if somebody fails to pay rent, not because they can't afford it, but because they're withholding it in order to try and get repairs. This may seem like a good idea. It is not. Do not withhold rent. Texas law requires that rent be paid in full and on time as it comes due. Withholding the rent could subject you to an eviction for non-payment of rent, even if you have the rent in your bank account. And except in very specific circumstances under Texas law, there is no right to cure. So once non-payment occurs, you end up giving up a lot of rights and you end up giving the landlord basically an easy path to try and get you out. If you're having problems with a remedy and repair claim, the proper process is to provide your landlord written notice that you are requesting repairs. We recommend that you send that request to your landlord via certified mail so that you can track it. If they still do not make repairs, you should contact a lawyer at that point. Additionally, it's worth noting that you only have a right to repairs if you're current on rent. Once you're behind on rent, your landlord does not have to fix your apartment. Additionally, your landlord, when they file an eviction, they can do so without the risk of you bringing a counterclaim for failure to make repairs. So just withholding rent, just don't do it. But actually, this is out of order. I'm going to go skip a few slides. So another special case that we normally, well, not normally, but that we unfortunately see is what happens if the tenant goes to pay their rent and the landlord refuses it for one reason or another. Generally speaking, a landlord is not free to refuse properly tendered rent. They are, however, allowed to refuse it if it is late, if it's only a partial payment, if you're offering a manner inconsistent with the lease. So, for instance, if the lease requires you to pay online or by money order and you try to tender cash, they're not required to take it. And they also don't have to accept rent if the lease has been terminated or an eviction suit is filed. If rent is refused, you want to review your lease, any notices from the landlord, and a current ledger to ensure that the amounts offered cover all rent that is owed. You want to document the date and time and manner of the payment. You want to document correspondence with the landlord. You should keep the payment or the funds available. That way, if the landlord changes their mind, you can tender those easily. And then you want to continue trying to tender rent for future months. And then finally, you should always contact a lawyer if you're dealing with an issue like this. Key takeaways: documentation is critical. Additionally, and this may be a case-by-case basis, but generally speaking, if there's a dispute about the amount of rent, it's often better to pay the higher amount and then explore other options to get the proper amounts credited than to simply not pay and face an eviction. It's always better to be on offense in these cases than on the defense. And unfortunately, eviction puts a tenant on the defense in ways that can be hard to overcome, even if there are clear facts in these cases. So returning back to the notice to vacate. So as I said, the landlord has to give a written notice terminating the right of possession and then demanding possession of the property. Notice to vacate begins the eviction process. So this is going to be sort of the first notice that you receive that the landlord is looking to exercise legal action against you. The code requires a 3-day notice unless unless the parties contract for a smaller or greater amount of time. Like I said, there are also federal regulations and federal laws that provide a greater amount of time for the tenant before the landlord can file. The notice to vacate has to actually demand possession of the property. So the language that the landlord uses is actually quite important. Delivery is also relatively important. The code provides 4 ways in which a landlord can deliver a notice to vacate. They can either hand deliver it to you in person. They can send it to you in the mail. It can be by regular mail or by certified mail. They can post it inside the unit in a conspicuous place. We're still waiting for case law to see, how far the courts will allow landlords to go in terms of posting it conspicuously. It used to be that you were required to post it just on the inside of the door, but they've expanded the amount of places in which a landlord could, in theory, post it. And finally, they can post it electronically if the parties have agreed in writing, either in the lease or in a separate agreement. Also important to note, it used to be that the landlord did not properly deliver a notice, that they would lose the case. The new rules basically allow the landlord to sidestep the delivery requirements if it's acknowledged that you've actually received the notice to vacate. So if you actually do receive a notice, then for legal purposes, that is valid delivery. I mentioned that there were generally no rights to cure under Texas law, except in one case. This is that case. The landlord must give you a notice to pay rent or to vacate if the grounds for the eviction is non-payment of rent and you've never been late or delinquent under the current lease prior to the current default. So if you signed a lease agreement back in May and you're unable to pay your rent in August on time, the landlord has to give you a notice to pay rent or vacate, giving you an option to uh, come current rather than face an eviction. If, however, same set of facts, you sign a lease in May, you're late in June, and you're running into issues paying now in August, the landlord does not need to give you a notice to pay rent or vacate. Um, you need to, uh, should be noted that the landlord can give a notice to pay rent or vacate even in cases where the tenant has been late before, and that right to cure then becomes valid under the fact that they've given this notice. So even if you've been late before, the landlord gives you a new notice to pay rent or vacate, you can still rely on their representation and try to bring the account current rather than face an eviction. If the landlord does not accept the rent, everything I said before about documenting that they're not accepting the rent, that needs to be documented, brought to a court because, again, once they make the demand that you pay rent, they have to accept it. Also important to note, oftentimes in these cases, landlords who are using online portals will lock the portals once the tenant is late. Make sure you document that you don't have access to the portal at that time, because if there's a question of whether or not you tried to tender rent and it refused, or whether they say you didn't, showing that you had no way of paying the rent because they locked the portal, that could constitute a defense or provide you potentially more time. Um, Important also to note, we talk about rent. Rent is defined by the lease. The TA lease defines it a little bit differently by including both base rent and other fixed and recurring charges. Rent does not include variable utilities or late fees. If the landlord demands that you pay rent within timelines under a notice to pay rent or vacate, the landlord has to accept the rent, even if it does not include late fees or utilities. However, failure to pay those amounts could constitute a separate breach of the lease, and they could issue a new notice to vacate if you don't come current on those amounts. Generally speaking, if you are looking to cure and bring the account current, we recommend paying all amounts that the notice says that you owe, not just the rent. Give me one moment. Another new rule that we have seen from the new law. There are new rules about how to calculate time under a notice to vacate. It used to be that 3 days meant 3 days. The new rules say that it is subject to the rules that the courts use to calculate time in other proceedings and other motions. And so that means that if the final day of the notice lands on a weekend or a holiday, they basically have to give you till the next business day to comply with the demand. So what does that look like in practice? We've got two scenarios. Scenario one, the landlord gives a notice to vacate on Wednesday, February 4th of this year. Under the rules, you never count the day the notice was delivered. Day one is the next day. So the third day, in this case, would fall on a Saturday. Because the Saturday is not a business day, they have to give you until the next business day to comply, which would be the 9th, which is a Monday. And then the 10th is the first day the landlord can actually file the eviction properly. The landlord files the eviction on the 9th. That is not proper, and the case can be dismissed for that reason. The same thing is true if there's a holiday. So same set of facts. February 11th, landlord delivers a notice to vacate. The third day falls on a Saturday. Sunday's the weekend, and then Monday's President's Day. So the 17th is the final day to comply with the notice, and then the 18th, the landlord can file the eviction. I should note that although the code is very clear about this, because these rules are new, we would expect some pushback here from parties who are not familiar with those rules or operating under the old rules. So if you see a situation like this isn't our case where reaching out for legal help, might be important. CARES Act, which is low-key my favorite part of this topic. The CARES Act is a federal law that was created back in 2020 during the COVID pandemic. It initially created a about 120-day moratorium on evictions for covered properties. But the end of that moratorium period, they created a new right to a 30-day notice to vacate for tenants in those covered properties. So what is a covered property? Covered property is a property that either participates in a program under VAWA, so that includes almost all federal public housing programs, so Section 8, project-based public housing, low-income housing tax credit, HUD-VASH, just a large number of federal programs. And then they're also covered property if they are receiving federally backed mortgage assistance. So if they have a mortgage from Fannie Mae, Freddie Mac, FHA, VA, that would make them a covered property. You're trying to figure out how if you're on a covered property or not. Some of these programs have quick searches. So for instance, Freddie Mac and Fannie Mae had a search function that they were using during the pandemic. You can look for low-income housing tax credit listings, but some of these are not going to show up on sort of normally publicly accessible databases. So if you think you might be on a covered property, you should talk to a lawyer and ask for assistance in terms of identifying that information. One of the things the new law did do is they attempted to change the way that Texas courts deal with the CARES Act. So they tried to redefine the federal law from saying that you're required to get a 30-day notice to vacate to instead read that the writ of possession could not be issued until 30 days after notice to vacate was delivered. Writ of possession being the document that allows a constable to evict you from the property. Our position is that reading of the law is incorrect. Our position is that this part of the property code does not override the requirement that you get a 30-day notice to vacate. However, this is one of the areas of the law that has not been subject to any appeals that would basically rule one way or the other on this. So if you do believe you might be eligible for CARES Act protections, it's really important that you talk to a lawyer because there's some likelihood that either the judge rejects it or that a judgment in favor of the defendant is challenged as not complying with Texas law. So the notice to vacate is delivered. The proper amount of time has elapsed, and now we're talking about the filing of the eviction itself. An eviction or forcible detainer, as we call it, when we're trying to be fancy lawyers, it is a lawsuit to recover possession of the property. So the main issue and the main focus of the case is who has the greater right to possession of the property. The landlord can attach a suit for rent if there's back rent, but they're only allowed to ask for base rent. They can't ask for utilities, late fees, or other sums. Those have to be brought in a separate lawsuit. The main things that a landlord has to prove to get an eviction, they have to show ownership of the property. They have to show that there was a breach of the lease. They have to show proper notice. And they have to show that the defendant refused to leave despite the demand for possession. And so it's important to pay attention to when the lawsuit was filed. I have seen cases where a tenant receives a notice to vacate, leaves, and the landlord tries filing an eviction despite the tenant being gone from the property. And those cases should be dismissed. So pay attention to that. We do oftentimes get questions about whether or not a tenant facing a forcible detainer suit is entitled to a jury. At the Justice Court, you can get a jury, but what you need to do is make sure you file a jury demand and pay all costs or get all costs waived at least 3 days prior to the trial date. If you need assistance with that, or if you're denied a jury, you should reach out to an attorney for assistance. So after the eviction itself is filed, the constable has to serve the citation, which is the notice that the case has been filed, to the defendant. The suit is always filed in the precinct where the property is located. There are multiple courts in each precinct in Harris County, though, so it could be in either of those courts. Trial has to be held within 10 to 21 days of filing, which means that the constable needs to deliver the citation relatively quickly. Otherwise, there's going to need to be a reset, and the new rules frown on that. Defendant needs to be served citation at least 4 days before trial. The code does provide that if the constables are unable to deliver the citation within 5 days of when the suit was filed, the landlord may have a different law enforcement officer serve the citation. We have not seen that happen yet, but the rules do allow for that to happen. So just be aware. It's no longer like the old days where the notice had to come from a constable. It could, in theory, be provided to you by a security guard who's been properly licensed and who has basically a law enforcement background, but he's working for a landlord in this situation. So just be aware that can be delivered in a couple different ways now, and should be on the lookout for it if you're expecting a citation. Really, really important potentially. When the legislature passed the new rules, it didn't just affect sort of your normal non-payment of rent evictions or conduct-based evictions. They also overhauled the section of the property code dealing with what we call forcible entry and detainer suits, which deal with squatters. The law distinguishes between evictions involving tenants who are given permission to possess the property at some point in time and squatters who are never given permission to possess the property. As I mentioned, the eviction involving the tenant is a forcible detainer. The eviction involving a squatter is referred to as a forcible entry and detainer. Most of the procedures in these cases, these two types of cases, are similar, but there's really one critical difference you need to be aware of. And that is in squatting cases, forcible entry and detainer cases, they created a new procedure called a summary disposition procedure. And what this does is this allows the landlord to plead that there are no contested facts and to basically provide the court the ability to dispose of the case without trial. So the court, in cases where the landlord is asserting that the defendant is a squatter and alleging that there are no contested facts, they have to provide notice to the tenant that the landlord's pled this. If you receive notice that the landlord is alleging that you are a squatter and saying that there are no disputed facts, or you see the word summary disposition, you need to act very quickly to preserve your rights. The rules require that you file a written response to the court within 4 days of being served, and that you plead in your response that there are facts in dispute. The most important fact in one of these cases that would be in dispute is that you're not a squatter. But in order to guarantee that you have the right to make that case to the judge, you do need to make sure that you file that written response within 4 days of being served. So if the landlord alleges that you're a squatter, how do you prove you're a tenant? Well, there's a bunch of evidence that you can point to that would indicate that you are a tenant. The first thing is showing that you have a written lease, showing that you have made payments to the landlord. So a record of payments, for instance, or receipts of payments, showing correspondence with the landlord that shows that there's been discussions, could show a landlord-tenant relationship. If you receive a notice to vacate and demand rent or it lists unpaid rent, that can prove you're a tenant. If there are prior eviction filings, that can prove that you're a tenant if they've alleged things like non-payment of rent. And then in post-foreclosure situations where the landlord basically purchased the property from foreclosure auctions trying to evict you, um, showing that you at one point owned the property, that can prove that you're basically a tenant, albeit a tenant sufferance. But point is that there are a variety of documents that you can use to demonstrate to the court that you had at some point some right to be in the property and that you aren't a squatter for the purposes of a forcible entry and detainer case. Our recommendation, because you just want to make sure you're protected, is to keep evidence of your tenancy, even if you don't believe you're currently at risk of eviction or believe that you'll ever be at risk of eviction. So, with all that said, how do you respond to the landlord's motion for summary disposition? First thing, you want to contact an attorney and seek assistance if it can be provided. They may be able to either provide services or advice, or I don't know that we have a response form, but there may be some template response forms that they would know about they could provide you with. You want to contact the court for assistance. You want to make sure you're filing a written statement. And it's not enough to say, I want my day in court. You need to actually dispute any of the facts that they're alleging. And so again, if you were a tenant and they're alleging a squatter, you want to allege that you have a landlord-tenant relationship. Also, best practices would be to file documents supporting the statement. So don't just say, I have a lease, but you actually want to file a copy of the lease alongside your motion. You obviously want to file as soon as possible, but file even if the response is late, because the court does have some discretion as far as hearing evidence, even if the tenant misses their opportunity to contest in writing under the code. And then if you do have a trial date, appear for it and any hearing date and make sure you bring the evidence with you to those dates. If you lose because of a summary disposition motion, that does not waive your right to appeal. So keep that in mind too, is that even if you fail to file the written statement on time for whatever reason, and the court doesn't hear your defense, you can still go down the appeal route. And we'll talk about that towards the end of this presentation. So whenever the landlord files an eviction, the case is always set for a trial. The trial is where the justice court hears the case, hears the evidence, and makes a determination on which side wins. It's important to note that in justice court, they use simplified procedural rules. The courts do not need to follow the rules of evidence. And so what you see in each justice court can actually vary differently from what happens in other justice courts. There are, for instance, two courts within about a mile and a half of each other in the third ward in Edo, and proceedings in those courts look very, very different. So just be aware, every court is going to want to hear evidence and want to try the case, but we can't walk you through what happened in each different court. I know the slide says to arrive on time. We actually recommend oftentimes arriving early. Some courts have resources available for tenants facing eviction or difficulties. So for instance, I do a lot of work out in Wanda Adams Court in Precinct 7, Place 1, and they have an eviction coordinator who is very good at lining up resources for tenants. And even if the resources don't get you out of the lawsuit, the resources could put you in a better position moving forward. So, you don't want to arrive late, but, if you arrive early, it may give you some ability to better your situation. When you arrive, you do want to make sure that you're going to check in with the court. Some courts check people in basically as they walk in. So they don't do a big docket call. Other courts actually do the docket call. So they get everybody into the courtroom. They call names, and if you don't respond to your name, you're marked absent. Um, so, just make sure that you know how they're going to check you in. If you need any assistance, ask the clerks, and then make sure that you actually are in fact checked in. Because if they don't, the court could basically find that you're in default and issue a judgment without hearing from you. Actually, to circle back a little bit, if you get citation and you're going to trial, but you need special accommodations for trial, so for instance, a Zoom hearing, if you're unable to attend, before you actually get to the trial date, you're going to want to contact the clerk to ask for the special accommodations. Some courts will give it as a matter of course. Some courts will require that you file a motion with the court. Some courts may even ask that you confer with the plaintiff to get permission, for instance, if you are seeking a Zoom hearing. But we do sometimes get questions about that. Direct those questions to the clerk. They should tell you what they need in order for you to get what you need. So once you arrive at court, once you're checked in, the docket is going to start. Some judges are going to give instructions on how the court's going to work prior to trial, so you want to pay attention to that. When it's time to start hearing cases, the court basically calls the parties up to the front. The judge begins by hearing the plaintiff's case. So they're going to have some questions to ask about why they're asking for the eviction, what amounts are owed, whether or not there's a notice if it's vacate delivered. Once they're done hearing from the plaintiff, the defendant has the opportunity to respond. The defendant can ask questions of the plaintiff, or they can simply talk to the judge. It's important that you're prepared to answer the judge's questions and provide evidence of your defense to the court. We do sometimes get asked, or we see people ask, whether or not the trial can be reset. Generally speaking, the trial can only be reset by motion of the plaintiff or if both parties agree to the continuance. In rare cases, the judge might step in and provide a 1-week reset, but those are fairly rare cases, and they're not usually cases where the tenant simply asks for more time. Usually there's some part of the case that the court wants more time with, or that the landlord needs to provide more information to the court. So, I mean, simply asking for more time is probably off the table for the tenant. At the end of the trial, the judge is going to issue judgment in favor of one party or dismiss the case. If you can, always get a copy of the judgment for review and for your files. And then just a general rule at trial, and this is going to be true both for the justice court and in county court, always be respectful of the judge, the court staff, and as much as it might hurt sometimes, the opposing party. It goes a long way to avoiding difficulties by simply treating everybody with respect and trying to follow court procedure rather than trying to talk over other people. And unfortunately, we see the latter all too often, and sometimes it does affect the outcome of cases. One thing that might happen at trial, either in justice court or in county court, is that there might be discussion of whether or not the case can be settled. Most judges are going to encourage settlements between the parties, and many will provide resources to facilitate settlements, such as standard settlement forms, or even some courts, they have mediators who can help parties craft a settlement. Settlement requires both parties to agree to specific terms. The parties determine what those terms are. A good agreement is going to be in writing, signed by the parties, filed with the court, so it's enforceable. And it should specify clearly what actions can be taken by both parties. Settlements can come in sort of two broad forms. One involves the tenant leaving, the other involves the tenant not leaving. If the parties are agreeing for the tenant to leave, you want to make sure it specifies the date and specifies the case will be dismissed upon the tenant surrendering the property. If the tenant is not leaving, you're talking about either tendering payment or into a payment plan, you want to make sure that the settlement agreement specifies the amount to be paid, when they're going to be paid, how they're going to be paid, and again, specifies the case will be dismissed. As I've mentioned, settlement needs to be in writing. An informal or unwritten agreement between the parties is not enforceable. So don't just take their word for it. Make sure that you are actually getting the agreement consigned to writing. Keep in mind, too, the settlement agreement can involve parties giving up rights and could impose penalties if you fail to comply with the agreement. I always tell my clients, when we're talking about settlement, that whatever you agree to is going to be set in stone. If you're agreeing that you're going to move on August 22nd and you're there on August 23rd, that could clear the path for the landlord to get judgment, and you may not be able to raise defenses at that point, even if you have them. So always make sure that before you enter into an agreement, that you are certain that whatever you were promising, that you can perform on the promise. Also important to note, especially in cases where the judges provide sort of standard forms, make sure you review all of the forms and sign only if you agree to all of the conditions. I've unfortunately seen in some courts cases where the parties intend to agree to a payment plan, but the actual document signed says instead that the tenant is agreeing to pay an amount and then leave by a particular date. And those can be very hard agreements to unwind, even if you have the ability to unwind them. If you do end up in a situation where they hand you sort of a standard settlement form and the terms don't work for you, always feel free to cross sections out, rewrite parts of it, or you could even just write your own agreement yourself. I can't tell you the number of files I have where the agreement was written on legal paper and filed with the court because the standard form just didn't work for what we needed it to work for. So, make sure that you're only agreeing to what you want to agree to and that you can perform on all the terms of the agreement. So let's say that you're at trial and the court decides in favor of the plaintiff, and you disagree with that decision for whatever reason. You do have the right to appeal. The way an appeal works is that you have 5 days after the judgment to either pay an appeal bond, which is normally set at 2 months of rent, or to file something called a statement of inability to afford court costs. The statement of inability can be obtained from the clerk's office at all of the courthouses. You want to fill it out completely. Most of them now include a section where you verify that you believe you have a defense. You want to provide both of those to the court. Like I said, those are due within 5 days of the judgment. Within 5 days of filing the statement of inability, you also need to make a payment of 1 month of rent to the court registry in order to avoid a writ of possession from being issued. And we'll talk a little bit more on that in the coming slides. Even if the writ is issued, your case can still be transferred to county court. It's just you're not allowed to stay on the property, or the landlord rather can remove you from the property while the appeal goes up. So some important things to note about the statement of inability to afford court costs is that the landlord or the court could challenge that pleading if they believe that the information that you provide is incorrect, or if they believe that you actually can afford to pay the appeal bond. Pay attention to if you get notes from the court saying that the SOI has been challenged. They have to set that for a hearing, and then at the hearing, you're responsible for basically showing that you can't afford to pay you can't afford to pay the appeal bond. Once you provide information to the court can make a ruling. If they rule against you, you do have the right to appeal. If for some reason you have an SOI challenge, I recommend reaching out to legal aid at that point immediately. We can screen you and provide you with a letter stating that we've screened your case and find that you are eligible. and that should prevent the SOI from being denied. Sorry, once all this is done, the JP court can transfer the case up to county court law where a de novo trial can be heard. De novo meaning that they're starting all over again from the beginning. As part of the process, they're going to be sending out notices to you, informing you about the date of trial and other deadlines that might be relevant. Make sure you're checking your mail regularly so that you're getting those notices. As I mentioned, the court requires that tenants appealing an eviction make payments of rent into the court registry. Initial deposit is due 5 days after the appeal is filed. And they are required to make payments in full and on time as they come due. So for instance, I don't have a calendar in front of me, but if you file an appeal and the payment deadline is August 31st, you do need to make a payment of September rent on September 1st in order to satisfy this requirement in order to stay on the property. So paying attention to those timelines is really important. Also worth noting is that unlike in the past where this payment requirement only applied to non-payment of rent cases, the new rules require that all tenants appealing evictions pay rent to the court registry, even if you're talking about a case where someone's being evicted for bad conduct or as a holdover. The court decides the amount to be paid to the registry based on the lease agreement. And so if the lease says that you pay $1,000 a month, that's what the court should be ordering to be paid into the court registry. If you're on public housing, you're only required to pay your share of the rent. So if the base rent is $1,000, but you're only responsible for $250, the court can only require that you pay $250 into the registry. If the court makes a mistake, you do have the right to file, we call a rent contest motion, basically laying out the amount that you believe you should be paying. That needs to be filed at the same time you file your appeal, because those deadlines are the same. The court then will hold a hearing, and you want to make sure that you provide evidence that your share is what your share is. So for instance, an award letter from housing. Also worth noting, if there is no agreement to pay rent, so for instance, if you're talking about a post-foreclosure eviction, the judge is required to set an amount to be paid, and they're required to set what we call the fair monthly rent for the property, which basically means that's the amount that the landlord in theory could get if they were renting the property instead of dealing with the appeal. If that amount is less than $250, the tenant must pay $250 into the court registry. And just keep in mind that we're talking about these registry payments. This is what prevents the landlord from going to the court and asking the court to issue an early writ of possession, which will allow the constable to remove you before the court date. So when in county court, case is heard from the beginning, so de novo. The new law requires the case to be heard within 21 days of transfer. County court, unlike justice court, they are a court of record, which means that they use formal rules of procedure and rules of evidence. You are required to file your evidence on time, as opposed to justice court, where you can arrive that day with the evidence. In Harris County, the filing requirements is that you file evidence the Wednesday prior to trial. But if you have any questions about that, I would direct questions to the clerk of whatever court you're going to be in. As I said, these are cases heard from the beginning, which means that what happened in justice court does not matter. The landlord needs to prove their case all over again. And they need to show that they're entitled to eviction both with testimony and evidence. And so you want to pay attention to what they have and have not brought before the court. and basically challenge them if they, for instance, don't provide the proper documentation showing that notice to vacate was delivered. Because county court can be a bit intimidating, this is another situation in which if you need help, you should apply for legal assistance. Um, Most judges will try to accommodate pro se tenants, but they do need to balance the need to keep their courts open to people without legal training with the requirement that they actually follow the legal proceedings and procedures required by the rules. We sometimes get questions about what happens if you lose a county court. In county court, if you are current on your registry payments, the court will normally set a writ date out for 10 days, which is the same amount of time you have to pay something called a supersedeas bond. The supersedeas bond is basically an amount paid to prevent a judge from being executed. They normally set it at 10 times the amount of monthly rent, and they normally require it due in the form of lump sum. If you're not current on registry payments, however, the court will, in most cases, allow the landlord to ask for an immediate possession to be issued after trial. So be aware of that. Your payments into the registry don't just affect the time you have leading up to trial, they can affect what happens after trial as well. We don't normally deal with appeals past this stage because at that point we're talking about a very different sort of appeal, which requires that you identify a procedural error by the court. And so you don't get another trial, but you'd have to basically have to take the record of this trial and identify sort of error that materially affected the outcome. In most cases, either there is no record or there simply is not grounds for an appeal to be heard. So in most cases, county court is the end of the line. So we've talked a little bit about writ of possession already. Like I said, writ of possession is the legal term for the document that allows the constable to remove a tenant from their unit. The prevailing plaintiff must request the writ of possession from the court. They're not allowed to simply post their own notice to the outside of the unit, but the judge has to sign off on it. It's then sent to the constable's office for execution. The constable must serve the notice to vacate. Sorry, must serve the writ of possession within 5 days, or the landlord can have a different law enforcement officer serve the writ. Like with the delivery of the citation, we have not seen a situation in which the landlord has contracted with a different law enforcement officer to serve the writ. Again, it's not outside the realm of possibility that the landlord may have hired a security guard whose day job is a police officer who may be able to execute a writ like this and may have the training to do that. So just be aware of that. The writ needs to be posted 24 hours prior to the execution. So once you see that's posted, you have 24 hours to leave before they can actually remove you. Upon execution, the constable removes the tenant, the properties, and changes the lock. And then, important to note, the writ cannot be executed in cases of bad weather. So if it's raining outside, it can't be executed. We sometimes get questions at this stage about whether or not it's possible for the tenant to get more time. The answer is generally no. However, oftentimes it makes sense to contact the constable who's tasked with executing the writ. Oftentimes constables are reasonable and they may be reluctant to execute a writ if you're able to simply leave before they're able to execute it. And so communicating with them could avoid the real worst case scenario, which is basically the forcible execution of the writ. You may be able to leave on your own even at that point. But again, you would have to talk to the constable who actually is required to execute the writ. So just to sort of wrap up the eviction segment, we oftentimes get questions about what is the timeline for an eviction. If you're not going to appeal or not in a position to appeal at justice court, you're talking about 21 days between when the notice to vacate is delivered and when a writ can be executed. The important thing about the short timeline, that assumes that everything goes about as quick as possible. I'd say probably 95% of evictions are going to take longer than this timeline. But if you are planning ahead and you want to know exactly what's the minimum amount of time that I can remain here, 21 days is sort of a good sort of point. With the appeal, that's extended to about 43 days, although the 43 days does assume that the court orders the case to trial within 7 days of receiving the actual transcript from the Justice Court transferring the case. I have seen it that short, but generally that's been after a longer delay in terms of the case being sent from Justice Court to County Court. But that's sort of back of the napkin math about sort of the shortest possible timelines. So moving beyond the eviction context, there are other challenges that might be faced by a tenant who is dealing with landlord-tenant disputes. The first is what happens if there's a lockout, and what happens if the landlord tries to shut off the utility. Generally speaking, self-help is not allowed under Texas law. The landlord cannot lock you out intending to keep you out of the property, and the landlord cannot constructively evict you by shutting off your utilities hoping you'll leave. It is important to know, however, that there is one situation in which a landlord could, in fact, change your locks on you. If you're behind on basically rent, and the lease allows the landlord can post a notice that they intend to change the locks, and they can change the locks provided that they give you the ability to obtain a key to the new lock within, and I believe it's 2 hours of when you first request the key. We don't often see those lockouts simply because, we don't often see those lockouts simply because, if the landlord gets a request for the keys at 2 a.m., they have to have the keys there by 4 a.m. So usually it's not worth their hassle to do that. Additionally, if they don't give the proper notice, if the lease isn't clear, there's potential liability for them, in improperly locking you out. Assuming that you are locked out, however, either through a wrongful lockout or through a self-help eviction, you do have the right to petition the court with something called a writ of reentry. The writ of reentry basically is an order from the court to the constable requiring that you be let into the unit again. It's an ex parte motion, which means that you do not need to serve your landlord, although best practice is to notify your landlord prior to filing this. Once you file, the court is supposed to give you a quick hearing. The judge hears the evidence. If the judge agrees you're legally locked out, they'll issue the writ of reentry, ordering the landlord to let you back in the home. You can file a separate lawsuit for damages. The damages are 1 month rent, $1,000 in actual damages, including court costs and reasonable attorney's fees, less any delinquent rent or other sums. So as in our case where documentation is really, really important. If you get locked out and you're able to basically stay at a hotel and get compensation for that, that's obviously preferable to being locked out and not having anywhere to go, and then not being able to recoup those costs. Additionally, if they lock you out and you don't want to remain, you do have the right to ask the court to terminate the lease. So, just be aware you have those remedies. Utility shutoffs are fairly similar in terms of how those cases go, and fairly similar in terms of the prohibition on the landlord shutting off utilities. The landlord is only allowed to shut off utilities if it's specified in the lease, or if it is, basically shut off, excuse me, basically utilities are shut off for the purposes of an emergency or repair. So for instance, if you are facing eviction, the landlord needs to shut off your water because there's a water main break and they need to make repairs, like that is a valid utility shut off. If they've illegally disconnected the utilities, however, um, you have the right to file a lawsuit, like the writ of reentry. This one's called the writ of restoration. It's an ex parte motion. You don't need to serve the other side, but it makes sense to let them know that you're bringing the suit. You see the judge, you present your evidence. If the judge agrees that the utilities were disconnected legally, they give you a writ of restoration, which is then delivered to the landlord, who's then required to restore the utilities. And again, there are damages that you can recover. We recommend a separate lawsuit. So documentation, again, is really, really key in these sorts of cases. Finally, we get a lot of questions about the security deposit. It's important to note that a landlord can deduct amounts from security deposit for any damages or charges which the tenant is legally liable to the landlord for. So, for instance, if you're behind on rent and you leave, the landlord can retain the security deposit in order to cover any amount that would be owed. Assuming that there is any amount left over, the landlord does have an obligation to refund the security deposit on or before the 30th day that the tenant surrenders the unit. That timeline's a little bit misleading because it's actually triggered not by the surrender of the property, but by the tenant providing the landlord a forwarding address. The landlord has to provide you, if they intend to retain amount from the security deposit, written description, an itemized list of deductions, unless there's no dispute that the tenant owes rent and there's no controversy about the amount that they're retaining. If you're looking to have a security deposit that's been wrongfully withheld returned, our recommendation is to send a certified letter basically demanding the return of the deposit and then to seek legal assistance. Security deposit cases like writs of reentry and writs of restoration do include the ability to collect attorney's fees. And so, there, even if legal aid can't assist, there may be an attorney who would be willing to assist in order to get those attorney's fees. So it makes sense to try and seek legal assistance dealing with any of those issues. Some additional tips. We always recommend getting ahead of problems rather than waiting for them to arise. A lot of landlords, will rather work with you rather than going through the process of asking for an eviction. And so, if you can get in early and try to be proactive, it could stop you from going through this entire process. Rental assistance, I believe, has run dry, but it still makes sense to check and see. Some local organizations may still be providing those checks. Likewise, take advantage of any community resources offered by the JP courts. I've seen people either get rental assistance or get new jobs, or even cases where they've lost, they've been able to get moving assistance to get them out of their current situation, put into a better situation. If you're having problems with the condition of the unit, make sure you pay your rent and then contact someone for help. Make sure you document everything. And then if you are seeking legal assistance, make sure you're seeking it from a credible group like Lone Star Legal Aid or Houston Volunteer Lawyers or Houston Eviction Advocacy Center. And that wraps things up for right now. So thank you for coming. We can take questions as you need them, but this is our information on how to apply and contact us. So yeah, if you have any questions, I'm ready to hear them.
Okay. Let me go through The chat here. I don't see any other questions in regards to in regards to what you have presented here. However, I did have a question. When you were talking about some of the forms, for people to file an appeal or file of responses or answers and things like that, if they can't qualify for legal aid services, are all those forms and documents and things available like on the Texas Law Helps website that they can go and get these forms, or do the court then provide the forms and say, hey, you were supposed to submit this document or X document or what have you?
So Texas Law Help has a lot of forms. I can't say they have all of the forms, but they do have a lot, and they do have, I believe they even have guided forms where if you need assistance in filling them out, um, instead of, simply, going down a checklist, they'll ask you questions and try to provide the information you need. The courts also have forms available at the courthouse. The clerks are limited in terms of what they actually can assist on. But like the statement of inability to afford court costs, that is available at all of the courts. The defense verification is usually part of that. That needs to be turned in, separately. They should have a copy of that as well. Um, they should have petitions for the writ of reentry, writ of restoration. They may have, actually don't know if I've ever seen a specific form for to recover the security deposit. That may just be something you fill out a small claims form, but I would check with Texas Law Help. They should have more information about that. Additionally, I mean, I should mention that, our firm, we do serve low-income individuals for free, and so we have income and asset limits. But some of the other groups out there, like Houston Eviction Advocacy Center, they actually provide their services to free for anyone. They don't have income or asset eligibility guidelines. And so, you know, don't take for granted that you're not eligible. I would ask.
Gotcha. There's another question here in the chat. What happens if a landlord is not able to pay for utilities due to no rent being received and utilities is shut off due to non-payment?
That's a good question. Um, I mean, if the utility company is the entity shutting off the utilities, that is a different question than the landlord shutting off utilities. I think that's a really, really key distinction. Now, if this is something where the landlord themselves doesn't pay the utility company, just pockets the money, utility shuts it off. I mean, there's almost certainly a cause of action against the landlord for that. But if this is something where, like, the landlord is responsible, that might be something where if this is like an actual like fact pattern, you may want to apply for legal assistance. Because it is a good question. Again, I think what's determinative is if the utility company shut it off or if the landlord shut it off.
Would it also make a difference if it depends on what it says in the lease? If part of your rent includes the utilities to be paid,
Well, again, there's a distinction
or
between there's a distinction between the landlord shutting off or the utility company shutting off. And you're you're talking about, like, we talk about utility shut off. The landlord is never supposed to be in a position where they can permanently deny the tenant access to utilities, because that would be self-help and that's prohibited. If they want to force somebody out or they want to uh, get payment, they're supposed to go through legal processes, either through the eviction process or if they're looking for payment through a small claims case. They're not supposed to be in a position where they say, well, you didn't pay me this, and therefore I'm shutting this off. Um, yeah, I mean, I guess the thing that I'm interested in, curious about, and don't know the answer to is whether there's any claim against the landlord for the utility company shutting it off when the tenant has only paid partial rent or hasn't paid rent. My guess is there's probably not, but I don't know if the code contemplates that particular fact pattern.
I had one of my coworkers that kind of went through something similar to this last year. And I don't know if it's changed since then, but um, the water service was supposed to be included with the rent. But because the tenant was behind on the rent, the water bill got to be an astronomical rate because of a leak or something or other, whatever. And basically, as they were still trying to evict the tenant, they were told that they still had to make sure that the water bill got paid because it was included in the rent. That because it was part of the lease that the landlord was providing that particular utility. It had nothing to do with the fact that the tenant hadn't paid the rent. They still require that the water bill get paid and that the water service be provided.
So the tenant may still
I,
be, tenant generally is still liable to the landlord for the utilities. It's just they can't claim those amounts like in a legal proceeding unless they are part of the actual rent. I think I mentioned that TA
yeah,
lease like defines certain fixed reoccurring charges as quote unquote other rent. And they do that specifically because, their position is that if you pay a flat utility rate, they're hoping that they can backdoor a claim for those utilities in with the rent. And some landlords like the rent is all inclusive, so it'll include those amounts. But I think like the point of the way the code is written is that the legislature doesn't want a situation in which a landlord is trying to deny a tenant rights or discourage a tenant from exercising their rights by simply, you know, refusing them the use of the property. So it's entirely built around how do we prevent the landlord from engaging in self-help. And so, when you put self-help sort of first, the design becomes a lot clearer. But again, that's a little bit different than what happens if the utility company itself shuts off the service to the property.
okay. Um, that was the only other question that was in there, and that was the only question that I had. Listening to everything earlier. Is there like a little one-page guide or like a something that kind of gives people like at a glance the new updates or the new laws or new changes that took effect from the first of the year that somebody could actually read and say, okay, now I know this is different from what was before.
I believe we have some handouts. I can see about forwarding those to you or making sure that anybody has them. I would refer,
Okay.
frankly, to Texas Law Help because
Okay.
they have a lot of that information. I'd also I'd also be a little bit reluctant to say just focus on a one pager because a lot of these changes are sort of wrapped up in sort of the way the law itself functions as a whole and reducing it to,
One page.
yeah, kind of,
Mm.
it, it's kind of stream of consciousness in a way that doesn't give you a sense of the greater process. Because if you don't understand that, for instance, um, registry payments are required and what the consequences for failure to make those payments, you're saying they're required in all cases, kind of hides the ball on that. And so, I mean, like I said, I would, if you have questions, apply for legal assistance, view Texas Law Help. The courts may have some resources available. Um, but no, I need to see if we have just a handout for that.
Okay, great. Well, I think that pretty much concludes our presentation for today. Again, as I had mentioned in the chat and earlier, a copy of this, a link for the recording of this presentation will be attached along with a lot of the different resources that Benjamin mentioned throughout the presentation. So if you guys have any questions, please feel free to reach out to those different resources. If you're not able to kind of find exactly what you're looking for, then please feel free to give me a call and I'll try to, you know, move you in the direction or provide whatever other assistance or resources that we have that are available to you all. But please do not, don't wait until the day before you do to show up in court to then reach out to an attorney for assistance. Try to do your best to get ahead of 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 what you can and communicate with your landlord if you are facing eviction, because sometimes I know a lot of times people's pride kind of get in the way. They don't want to ask questions or ask for an extension or ask for a partial payment or a payment plan. Reach out to the landlord. You never know if they'll be willing to, to at least work with you and, take payments and things of that nature, as opposed to just not communicating with them at all. So that would be my 2 cents. But I will send out a copy of the calendar for the remaining workshops that we have that are scheduled for this month. If you guys have any questions, or if you want to come back, if you want to attend future presentations, the link for the website to go and register will be included on that presentation. But again, if you guys have any questions, please feel free to reach out to us and reach out to Lone Star Legal Aid for assistance. So with that being said, thank you very much, Benjamin. I really do appreciate you coming out this afternoon and providing us with an update of what's going on. And we will see y'all next time. Our next scheduled presentation potentially is going to be in October for evictions presentation. Thank you, Ms. Teresa. Um, uh, and we will send you all out the notice about that, as the date gets confirmed, or just kind of pay attention to the website on our events page, and we'll make sure that the schedule is updated accordingly. So. With that being said, you all have a wonderful remainder of your afternoon. You all take care of yourselves and you all stay safe. And we will see y'all next time. Thank you, Benjamin.
Thank you for having me.
All right.